I've seen a couple of equivalent issues in the comments. Problem is, if you meet that 40-day timeline, then strictly speaking, SARS is not actually required to look at it because your object, and this is one of the issues which has actually been raised with SARS by the varying RCBs, is to go and say, but guys, come on. My objections and appeals time frame gives me 30 days plus then an extension. Okay. This is, and if I'm auto assessed, then whereas I was thinking I may only need to look at my returns in October, I'd now have to look at them in August. Okay. The problem with, generally in my experience, if you've been auto assessed and you can't do an objection, it's because you're outside of the timeframes. I'm happy to go and take commentary from someone else who's had a different experience because heck, that's part of the beauty of working on e-filing is that sometimes the rules don't work quite the way as intended. But I think this is something which we are going to have to start talking to our clients about as well. Is if you these time frames that SARS gives us are not negotiable. They are legislative requirements. And as such, we don't get to just have a flexibility of whenever it's convenient for us. So that's the downside. The upside on this is we do know that there were issues with the extensions that were granted or the request for reasons or the whatever issues you had with your auto assessment. So if you can show that you tried to object within the time frame and SARS disallowed it, that's something which I would definitely escalate to your RCB and get them to have a look at because there's clearly an issue there, which then is not just I missed my time frame. There's clearly a systems glitch that's available to it. Okay. Tied in with this, I will be honest and go and say that I have definitely since the end of the 40-day period, so since about mid-August, I have seen very few additional assessment issues come through. Most of them seem to have resolved themselves by then. But there are definitely still gremlins in the system. Okay. And if there are gremlins in the system, we are going to be looking at your RCB as being able to help you and a discussion with, and also the fact that SARS is acknowledging the fact that they're trying a new filing, that they're trying to make improvements to the e-filing system, which may not be perfect, and they'll work with you. All right. To answer the question as to whether the 40 days is legislated, no, that 40 days is actually not legislated. But the SARS's argument, and there are those RCBs which disagree, so I'm going to put that out there. SARS's argument on the 40 days with the additional assessment is because if you go and look at the Tax Administration Act, the Tax Administration Act says that where an assessment is issued, the taxpayer has the 30 working days to object to the assessment. So the view from SARS is effectively that the 40 days they give us on auto assessments is actually gracious because it goes beyond what's actually required under the law. There are some concerns because strictly speaking, that auto assessment is an estimated assessment. And therefore, if we look at what you can and can't claim, there is a school of thought which argues that SARS actually isn't entitled to make the estimated assessment. The problem we have is that we can make the argument, but that doesn't mean SARS accepts it. And it has been made by various RCBs before already. So realistically, the auto assessments, the 40 days is actually gracious under a SARS impression because of the fact that it goes beyond the 30 days in the Tax Administration Act. It's done in terms of our estimated assessment provisions, which also counted as an assessment. All right. So there is definitely a point of view to say there's potential problems here, but it's not as bulletproof as you think.